What is everybody? Welcome to Truth and Transparency. Good morning, Thursday. Sarah Boone trial coverage. Come on in. Let's get after it. Woo! Well, hope you guys check it out on your own. But if not, yesterday was a lot to do with a psychiatrist who had visited with Sarah Boone 9 times. So that was a testimony. Now, we are dealing with a motion that was filed by the state. By the state. Um, so that motion, it's not me being muffled, it's this thing. See? A motion filed by the state, and they want Sarah Boone's defense team off the case. Well, Lana, why? Why would they do that? Well, guys, I'm going to show you why. Here we go. Sarah Boone's defense team is all working pro bono, meaning free, right? Pro bono. Except for her investigator. Because remember, Sarah Boone is an indigent. So she had all these public defenders. But there is a person that's still on her case that was the investigator, okay? And he was getting paid, all right? So the state filed a motion yesterday stating a conflict of interest because Sarah Boone's whole defense team, minus this investigator, so the investigator is getting paid by the state. Her team is working pro bono, but her team, specifically her lawyer, is alleged to be getting basically the rights to Sarah Boone and her story. Okay? And so I'm going to share this with us, and then so come on in, shake it down. Woohoo! Get rowdy. Let's do it. Okay. I mean, this is wild, but let's take a look.
In the Casey, I'll get rid of him. Ugh. You know, it's really never good when it looks like you planned a self-defense killing. This is where I bring in Joel Waldman. He wrote the book, Surviving the Survivor, and has...
Oh, shit. Ashley Banfield just comes out and says, it doesn't look good when it looks like you planned a self-defense. Wait, what?
I'll get rid of him. Ugh. You know, it's really never good when it looks like you planned a self-defense killing. This is where I bring in Joel Waldman. He wrote the book, Surviving the Survivor, and has a podcast of the same name. He was also...
You guys, what in the world is going on in the world? Okay. I'm sorry, but it is now being said that Sarah Boone, it looks like she planned a self-defense, like, killing. Like, she planned to... What? Wait, what? Wait.
In the courtroom today. Okay, so let's just start off by some exclusive reporting that you also got, very different from what we just heard. And it is that the defense attorney, James Owens, this would be attorney number 9, might be in some hot water. There's been a filing by the prosecutors against him saying that there's a conflict of interest. Tell me.
Okay, remember when she said Ann Taylor was going to be in hot water when Ann Taylor, the defender for Brian Kohlberger, she had a conflict of interest because she was the public defender's office. They have to represent all these idiots to get in trouble that can't afford lawyers. Okay. Just listen to this, man. Listen to this. This is how, when you don't have any news, let's just make up some news. But there is a filing. Tell
me what the story is. What's happened?
Ashley, good to be back with you. And let me just start by saying truth is definitely stranger than fiction. You can't make this up. So tonight while I was podcasting my show, Surviving the Survivor, had to be sometime after 5:30 or 6 in the afternoon. The state filed an unbelievable motion, basically questioning a conflict of interest between Sarah Boone and her entire defense team. And that is because they are all working pro bono, except for the private investigator. She's got 4 attorneys and a jury consultant. And this motion is alleging that Sarah Boone is indigent. She has no money, so she's using taxpayer dollars to pay the private investigator. And then James Owens, allegedly, according to this motion, that he worked out some kind of deal with Sarah Boone to get the rights to her story. He could write a book, documentaries, movies. And so now the state is asking for an in-camera hearing tomorrow, meaning going into the judge's chambers, just the lawyers to disclose all the financial issues here. It could get ugly. This is a curveball that no one expected.
Woof. Yeah,
What do you
that
mean?
doesn't sound very good, especially when
Yeah,
you're
it
right in the
does.
middle of
It
defending.
sounds
I don't know
fucking
about maybe
normal.
later if even that is ethical, but I remember something like that in the Casey Anthony case. I'm going to have to go sort through my notes, but
Go
quick
sort through
question.
those
I think I only have a couple seconds left, but the "I'll get rid of him" text, that can't have gone over well.
No, not at all. I mean, that was brutal. And look, the actually the second forensic psychologist from who you showed previously, her name was Dr. Julie Harper. She got grilled on cross. It was ugly. The prosecutor basically asking, "Hey, you know, she told you she got really mad at George Torres. You never asked her why she got mad. You never had any follow up. Plus, she was drunk. How do you know she was telling you the truth?" It was one thing after the next, and he just said no further questions. The courtroom was kind of stunned, and Will J., the prosecutor, I saw in the hallway, thrilled with the way it went.
Yeah.
I can imagine. That's one of those days you're,
You guys
you're
see
going
this
home happy.
biased
Joel Waldman,
coverage?
great job. Thank you for this. Appreciate it.
That is, I mean, we'll play it. That's not what fucking happened in that courtroom yesterday. Okay. Unbelievable. I'm sorry, but just unbelievable. So this is what is now going on in the world. Let's see. Oh, wait. Oopsies. I don't even know what the fuck I just did.
ACO 2603, State of Florida versus Sarah Boone, announce your names for the record, beginning with the state.
David Cacciatore on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah.
Thank you for the new member.
Raise your right hand to be sworn, please. Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table, buttressed by her attorneys, wearing a black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel?
Yes.
Defense, anything we need to address?
Yes, Judge, I intend to introduce these 2 exhibits that have already been stipulated to. One is you going to walk in what's their name?
Right now, their ID is AD as in boy and EC as in.
Defense gets identification AB, Judge, which is the order dated June 16th, 2019. It's a no contact order. And then identification AC. And it is a no contact order dated June 19th, 2019. And then I'd like to introduce them into evidence. And then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do you want to do that now before we're going to adjourn?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised, and we'll use our time accordingly.
That was the 6th.
I don't believe so. Give me a moment, and I can check.
What is up, everybody? Good morning. Why is it? It's got that staticky. Like,
That is an alternate. It's alternate seat 4.
Thank you.
Defense, do you have any motions?
The state has a motion. This is wow.
Just out of abundance of caution, I would read new or motion for judgment of acquittal, pursuant to defense resting. I'm going to do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge and the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
The defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night.
All right, so Sarah Boone says, hey, I'm happy with everything that's going on. I have no more evidence that I want to put on. I have no more witnesses. And yes, it's normal when you go to a directed verdict and that they deny that. So Sarah Boone wearing her pink shirt.
Is there anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good.
Sarah Boone has 4 attorneys that are pro bono. Okay, 4 attorneys. 2, I believe there's 2 female, 2 male. And then she has an investigator that's being paid. And that's the state's problem. The state is saying that her lawyers have a conflict. Well, and I'm saying that they don't.
All right. Can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand.
All right, so they're bringing in the jury. All right.
Jury's entering.
What's up, Boston baby? Shake it. All right. I will be doing a live call-in Sarah Boone show. And that is during Verdict Watch. So I just noticed that someone said something about doing a Zoom or something, had people come up on panel. Just hit the button when I'm doing that live Sarah Boone. I want all the crazies to come on out here and victim bash Sarah Boone. I want to hear these fucking idiots get on panel and start talking shit. Okay? People don't even want to know what I have to think about this case at this point.
A little bit of additional evidence presented by the defense this morning, and then we'll go from there. Okay? All right. Thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AD and evidence.
No objection to AB or AC.
What was pre-marked as defense
These are no contact orders.
team, and if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense
Woohoo! Watch for the laughs.
AC and evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
You guys, nobody is talking about the fact that Sarah Boone's defense team literally impeached the lead detective in this case. Nobody wants to talk about that. She fucking lied on the stand about a witness statement. Nothing to see over here. I mean, we lost our fucking minds.
Defense exhibit.
Put yourself, again, all they're passing out there is a no contact order, 2 of them. Put yourself in her shoes. A police officer is lying on the stand in your fucking murder case. Who the fuck do you think you are? And people out there want to talk about the psychiatrist from yesterday being like Sarah's lover or some shit. I'm going to be fired up today and I'm loving it. This is bullshit. It's a top lie in my case. I can't wait to talk about my case.
Next document is exhibit, defense exhibit 20.
Wah, wah, wah. The state wanted to suppress evidence, factual evidence of Sarah Boone being a domestic violence victim. Who the fuck does that? That's part of the case. So right now they're passing around this these no contact orders so people could see them. Okay. Yeah, impeached and making up reports. Yeah. Yeah. Like fucking nothing to see here. It's not a big deal. They just like you guys, if I was the defense, I would have shown way more videos of how they were always videoing everything. Okay. But he got into the suitcase. He got hammered before he got into the suitcase, gets into the suitcase, allows it to be zipped up. Okay. And Sarah didn't help him out of the suitcase. She goes upstairs and goes to sleep, and he dies. For people out there to say that this was murder, that means that she would have put that suitcase down there with the intention to say, motherfucker, I'm going to get you so drunk, put you in that suitcase, and then not let you out later. That's what people over there in mainstream media writing in chats. What the fuck? That's a great plan. She also beat him with a bat. I wouldn't say beat. I go to the autopsy with that. This isn't murder. I believe Sarah planned her actions against. Awesome. She poked him. She poked at his hands. She's guilty of something. He died as a result of her actions. See, it would be a result of her lack of action, actually. It's not a result of Sarah's actions. That's why the autopsy is so important. The autopsy is telling us the cause of death. And the cause of death was not from any blows to the head, or she rendered him unconscious, or anything like that. Positional, because of the way that he was positioned, and environmental. And so she's guilty of something. I mean, it's going to come down to if they find her guilty of manslaughter or if they acquit her altogether. She refused to help him. Actually, guys, you can't say that she refused to help him. Okay. Because the video is only like just a smidget of it.
State, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
Okay, here we go.
Dr. Tanya Warner.
Dr. Tanya Warner. Now, rebuttal is so like the defense just put on their case. Now, if they want to have a rebuttal to something that the defense put on, so I think they just said the word doctor. So I'm curious to see if this is a rebuttal to the hours of testimony from the psychiatrist from yesterday. I'm just saying, like, what if this wasn't on video?
The testimony you should give, shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tanya, T-O-N-I-A, Warner, W-E-R-N-E-R.
Thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And
Knew
what
it.
services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have.
Approximately how many?
Thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are.
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
No, it's
And,
not. Everybody knows that. The subcategory.
Where, if anywhere?
You know what's funny? I want to know if mainstream media starts going ham on this woman for having all of her books out, like the people did against the woman yesterday.
Specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access the funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular
You guys
case,
have a funny
we
story
asked
about that.
to do an
I bought these
evaluation.
season tickets,
Sarah,
motherfucker. They are my season
Yes.
You
tickets.
see Ms. Boone in the courtroom today?
But I'll let
I
you
do.
sit in my
Can
seat.
you point out
I got
where she
3
is
of
and
them.
what she's wearing?
She's sitting at a table there, wearing a dark suit and a pinkish top.
May the record reflect she's identified the defendant.
Are those
Record
my
so far.
season tickets? What if you
What
break
date
up? You
did
still get
you
that
have
one
an
spot?
evaluation
Fuck out of
with Ms.
here.
Boone?
Those are my season.
It was early in October. I believe October 2nd.
And this was
Sorry.
at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And where, who was present for this evaluation?
The defense and the prosecution.
Oh, they evaluated her. Okay.
Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just to make?
Just, if you need them to refresh your memory, please do so, but don't read from them. Just
All
let
right,
us
this is
know.
good.
So she had a difficult time recalling what time they actually woke up that day.
Same here.
Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4:00 in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there. And completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call.
Was it before that he was drinking?
Because they were already drinking. And she also at some point encouraged him to call his brother because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother. And according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up. And they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her. And she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
This is the most important part.
Refresh your memory, just
Yes.
put them down and then tell us what you remember.
This is the most important part. How do you have to refer to your notes about this most important part? What the fuck? She remembers all that other shit, but the most important part?
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol?
She didn't say that she recorded him.
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
And considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to you's consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
Yes.
It can.
The fuck?
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
It can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Exactly.
Generally speaking, it is important as an evaluator to get as much information as possible
Duh.
for rendering an opinion, such
Duh.
as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
Oh, right.
What was
There we go.
Your opinion.
That's what you need.
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Which was when?
And specifically talking about
Yes.
There we go. Absolutely, you need to approach on that. Okay, so it's your job to get more information out. Okay, like I want to speak on this. So I had a friend who was like, "Hey, Lana, will you help me? Like, I don't understand what the fuck is going on with my divorce stuff, and now I'm trying to get labeled like that my friend had raised her kids the whole fucking time of this marriage. The man, her husband, he was the breadwinner, so he was always working, and she always raised the kids. And then all these years go by, like 13, 14, 15 years go by, and they want to get a divorce. Well, he thinks he's going to take the kids from her. And I was like, get the fuck up out of here, motherfucker. I was like, did they assign a guardian ad litem? What are they doing? I was like, no, like, first of all, you're going to get alimony. Second of all, you're going to get child support. You're going to get half of everything. This is the law, and you do not settle for anything less. But number one thing is, are they going to be assigning like a guardian ad litem? Because you're not, like, if you want to be making deals, I was like, divorce, family court is the biggest fucking money grab in the world. And when you don't realize that as a human being, then you're going to just literally fork out all of your money to somebody who doesn't give a fuck about you or your motherfucking kids. Okay. So it takes a lot, and it should. It takes a lot to lose parental rights. It takes a lot to lose custody. All right. Criminals have custody. So always remember that. So, needless to say, I noticed that this guardian ad litem that she had, I was like, where is this motherfucker? I was like, let me see his billables. Let me see this. Let me see that. Okay, this is how we're going to attack this. This motherfucker has not even been around. You know, you haven't even met with him. Like, he's not hanging out with your kids. He's not coming to things. Like there's rules and statutes against this. Like, but anyways, moral of the story is that you cannot meet with somebody and ask them a couple questions and then say, well, I couldn't get anything out of them. Well, that's your damn job. Okay. So I'm going to spin it on you. And that means you don't know how to do your fucking job. Because you need to come across to this person that you're there as not, this is not teams. Okay. If you're a professional and you have integrity, then you want to come across as, hey, I'm just trying to, you know, this is so-and-so, I'm so-and-so, da, 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 da. Like, I really want to know, like, invest yourself for the truth or get the fuck up out of my face. Okay. And so needless to say, I was able to help my friend and, wrote up her a nice, 10-page motion to strike the fuck out of the guardian ad litem. You gone. Here's all the case law. Wrote on up. And I was like, just send this. He'll probably back off. I think it's hilarious how a person that does not like this or anybody, even if you're around somebody or talk to somebody for 2 hours and, oh, I know, or, oh, well, right there. I couldn't get anything out of her. You know what I call that? I call that a bare bones investigation. All right, write that down. Bare bones investigation. And that is against Supra Rule 48. When you don't do certain things, for example, in divorces, if you're having a guardian ad litem, you cannot have a bare bones investigation and that be admissible in a courtroom. So in this situation, I would think that this would be a bare bones. Yeah, I 100% Heather. This is a bare bones, and I would argue up and down, and I would die on this argument. Let me see if I can find my my motion that I wrote. She's like, I can't believe that you just did this for me. I was like, why wouldn't you believe I would do this for you? You're not gonna get fucked. You've been taking care of your kids this whole, like, you're an amazing mom. Like, get the hell out of here. You're one of my really good friends. Oh yeah, here we go. I got papers everywhere. What's this one? Oh. Let's see. So if any of you guys are out there need divorce help, let's see what I got here. Oh yeah, here it is. Now comes defendant and asks this honorable court to remove guardian ad litem from the above captioned case for failure to investigate, failure to be timely, failure to interview relevant persons associated with case to determine facts of the case, failure to report a conflict between the wishes of the guardian ad litem and the child, bias, and misconduct. Let's see. Number one was, where is it? Failure to investigate. Failure to investigate. So-and-so investigation falls far short of rule whatever, which is the standard set for guardian ad litems. This person's work is the reflection of a bare bones investigation, which by all accounts does not meet the minimum threshold. In short, so-and-so report failed to address with a finding any of plaintiff's allegations from said motion. Defendant notes at least 20 allegations within plaintiff's motion that go unmentioned in this guardian ad litem's report. Defendant, after reading the guardian ad litem's report, is unclear as to what, if any, investigative measures were taken by so-and-so over the past 2-year period to determine what are the facts associated with the above captioned case. Defendant attempted to answer her own questions after reading his report by referencing so-and-so's detailed billable hours. Unfortunately, so-and-so's billable hours did not provide any clarification or insight into any specifics pertaining to time allotted for investigative research of said allegations. The defendant was left with more questions than answers, as so-and-so only spent a total of 8 billable
Members of
hours.
the jury, thank you so
within the
much for your
first 4 months of
patience.
this
I have a
case.
matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to
Yeah, we do.
figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
I just ripped to shreds. Anyways.
Y'all can be seated. Thank you.
All right, let's see what's going
Mr.
on
Owens,
here.
if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer
Billable
that
hours.
Sarah Boone
Love
had
the name.
narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had the other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. And I refer to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And
This is
Dr.
amazing.
Warner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay,
that addresses specifically opinions
let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to pose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Warner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Warner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have.
I can't wait until Jennifer Drake's deposition comes up in that fucking trial that's coming in January. I hope that there's a deposition, some transcripts to talk about that shit.
Page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, That's how she answered. She goes through a little bit of that.
We need to get Jennifer Drake evaluated. This is giving me ideas. Miss Drake, we're going to get you evaluated. Have you ever been evaluated?
And then, paraphrasing, she talks about the grandiose component of criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits.
Yeah, and traits.
That was the examples.
Excuse me for interrupting, but can we lasso this back in?
I understand that's what the depot reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19, no. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your
Why
notes?
is she in there?
Line 24, answer, I may. Number 25, question.
Why is she in
Okay.
there?
And that's something you will let the lawyers know about if that changes. Answer, line 2 of page 47, yes.
Yes. Yeah, right there. Bye-bye. Bye-bye.
That's specific to the post-traumatic stress disorder.
It is specific.
Okay.
It says it right there. Bye-bye.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
Yeah,
I
and you're
would
going to
not
win.
take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
Yes.
What
I
are the
will be notified of any changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
It's incompleteness of evidence.
I understand the backdrop.
It's incompleteness. It's the incompleteness of evidence.
I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was.
Come on, it's fucking.
Response.
Judge, I don't appreciate the implications that they're making.
What?
What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm
Why
not
the
asking
shift?
her about
So
her
sudden.
diagnosis of PTSD. I'm not
You
going
didn't
to be
have a
going
problem
into
with that?
narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness.
Exactly.
The answer was a
That's not
definitive
the
no.
attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
God damn it.
And that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not
Okay,
apply.
that's irrelevant with the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed.
Well,
And
then
the
why
opinion
did
that was offered at the
then why did she
deposition was,
say
I'm
no?
not sure.
then why did she say no?
And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told
So
me.
impeach the
That's
witness.
unfortunately not the answer that was given.
Then impeach her. Impeach
So
her
what
on
is it that
cross.
you're asking me to do at this time, Mr. Owens?
This is a Brady violation.
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because
Impeach her on
opinions,
cross.
diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
Can I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the
Now that she
defendants
just
related
heard all
to
of
you,
this,
what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior
Why aren't
instances
his
of violence,
teammates
would
helping
that
him?
change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
strike it.
Number
And
one,
break-
she's given a legal opinion. Number two, it's a discovery violation.
Yes! Fuck yeah! Brady, baby! Woo! Finally!
What is the legal opinion?
Get me in that
The
courtroom!
post-traumatic stress disorder doesn't
Told you it was
apply
a
in this
knew
case.
it was Brady.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was gonna be her opinion before today.
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
gonna have to read the whole transcript.
Yeah.
No. This is a 87-page transcript.
Well, go home and read it.
You're objecting. You have the burden to establish your objection.
Give me a minute, I'll read through it and find,
Yeah,
Or I
ask for
asked
a
her.
minute. Ask for a 15-minute recess.
I mean,
Morning
this isn't the
break.
first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know
Boy,
in coming
dear
into
her.
today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided,
Why is she
which was
sitting
the whole
there
crux
still?
of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66.
She didn't have any money. Boone didn't have any money.
Line 20.
66.
Let me know when you're there, Judge.
Hang on.
This is amazing. Come on.
Yes, sir.
These lawyers need to help him out.
66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. Then I go into these. Then on 67, line 7, question, just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer, that I've been asked about. If I'm asked something else, that I'll offer it. Number
What?
12. Question, and you've been provided all the resources you need to rely on and express your opinions. Line 14, answer, I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion.
Toe tag.
I believe it's a discovery violation. because
Yes!
we've been notified of
It is.
opinions. Here-
Yes, it is.
We had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial.
And they just heard that shit.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the
Fuck
question.
your proffer.
The expert, it's been so long
I
now.
don't give a shit about your
Madam
proffer.
Clerk, or Madam Court Reporter, are you able to reread
You just
the
said
portion of
no.
the proffer as to what Mr. J asked of the witness?
Yes, come on.
Absolutely.
Do they switch
Of
up
course.
court reporters? They usually don't do that. Did she do her hair different? Everybody making fun of how big her shoe was. Dude, how is that fucking witness sitting there throughout this whole thing? I want to know how the witness is sitting there throughout this entire thing. Every time that they did this type of stuff in, like, Karen Reed's case, that witness had to leave. This is so inappropriate. I just think it's improper. Oh, God. Let's run the tape back. We got instant replay going on right now. Tom Brady, Peyton Manning, showdown. The doctor saw the patient for 2 hours one time. I bet you mainstream media, though, they're like completely the other way.
Court's going to step off for a moment while Madam Court
Yeah, it's
Reporter
gonna take a
is
minute.
able to provide that readback. Just
Oh my God. 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 Well, things got fiery in Orlando. Orlando! Home of the finest strip clubs. You guys thought it was home to Disneyland. Home to the finest strip clubs. Go check it out if you don't believe me. They fly their girls in from New York, where things are made of. Oh, you guys. Go Vandals. Go Vandals. Fuck yeah. You guys better be tuning in for the best coverage of the Moore Drake case live from Idaho. One of our lucky winners on this channel, if you can travel, I am giving away a 1-bedroom condo on Lake Hope for the trial week. So it's kind of like Kelly and Regis back in the day. We spin that wheel. You got to answer some questions. So, but yeah. Woo, woo, woo. Can you do a recap? Yeah. Well, this is exactly craziness. Can I do a recap? Shit has just gone wildly left. I'm down to go. Woo! Yeah. Yes. Excuse? What? I'm down to go. Yeah. So, God, 2.5 hours spent with their. This is what happened, guys. Obviously, this her new attorney came in a little late in the game, but they had a deposition with her. During that deposition, that is testimony, and during that deposition, she said her shit. You know, whatever it is that she said, and she said here today. So when I'm talking about PTSD. Have you formulated an opinion on PTSD? And that's what we're getting the readback on now. The exact verbiage, because the exact verbiage when she did her deposition was that she couldn't formulate an opinion because there wasn't enough information. And that's what she kind of was saying here today until she went ahead and was just about to say that, you know, she has characteristic traits of adjustment disorder, narcissistic personality trait. And I said, well, if that's the case, Miss Drake needs to be evaluated. That's right in my notes. Let's get Miss Drake evaluated. I want to get the Moores evaluated. I want to get the Drakes evaluated. And then we're just really going to have some awesome psychiatry going on here. Bombs are coming in the Drake Moore case, by the way. And if you want to win tickets to come and have a condo on Lake Hope, I am giving one away. You just have to get your ass there. Your food and room and board is taken care of. It's kind of like college, you know. Just get your ass to college. Get your ass to Idaho. Who even lives by Idaho? You know. So I'll be live streaming both trials. It's going to be pretty amazing how I'm doing it. I'm having both of my channels running. I'm doing a trivia night. So you guys, I used to own a trivia company. So I'm doing a Drake Moore trivia night. And it's a 1-bedroom condo on Lake Hope. So while you're there, your room and food. Pretty good deal. Seems to me defense failed to continue her evaluations. No, it's if her opinion was going to change, she had to notify the defense. She never notified the defense that her opinions were going to change. Okay, you can't just change your opinion in the middle of a trial. Especially like just everything that was going on. This was a rush situation. And the woman is over here claiming that I want to know what she reviewed. So in my notes, usually you're supposed to say, okay, what material did you look at? Like, I think these lawyers really need to consult with lay motherfucking people like myself. Okay. Because as a juror, I'm trying to take notes as if I'm a juror in what you're saying. And it's just like, okay, but what did she look at? You know? So when she met with Miss Boone, she met at the jail with Boone and her lawyers. Okay. And it was for just under 2.5 hours. She asked her general information. She asked her background information. I got to put mute on that. Like, I can't listen to that shit anymore. Educational, work history, her marital history, her health, mental health status. And then he stopped her right there and was like, can you elaborate more on that mental health? And yeah, like her memory, her thought process, her, you know, the way that her brain thinks, the way that she like fluidly thinks. Okay. And then we walked through the incident. Well, what do you mean about your marital? Like, wouldn't you want to ask questions about, like, what about your kid? You know what I mean? Okay, marital kid. Like, what do you do for fun? What are your hobbies? Like, when you want to try to get to know some, like, hobbies, like, shouldn't hobbies be in there? Oh, well, it wasn't. Like, I don't know what y'all did for 2.5 hours, but like, I just say I couldn't really get much out of her. Well, then you suck, and maybe you should have went back. But then they walked through the incident. And she says she didn't really recall the time that she woke up. Maybe it was the morning, maybe it was the afternoon. They both wanted to drink though. But they cleaned the house first, vacuumed. They had a half a bottle of wine around 4 p.m. on the porch with a couple beach chairs. There's a dartboard out there. They did some artwork. They did some puzzling. They finished a puzzle. She was frustrated about life, or Jorge was frustrated about life because he lost his job. Okay. She was encouraging him to talk to his daughter, encourage him to call his brother. And tell him about pulling me down the stairs by my hair, but he wouldn't say that. Like, he didn't tell him. So I guess then she was saying it in the background, you know? Then they went and got another bottle. They drank more inside. They got cigarettes, though, when they went and got that bottle. Then tag you're it. She went up and hid in the shower. She waited for him to come. He never came. She comes back downstairs. Well, she was coming back downstairs, getting out of the shower where she was hiding. She saw in the living room that he was slipping into a suitcase that they were planning on donating, and that's why it was downstairs. They were laughing and enjoying this time. She became angry all of a sudden. Like, hello, you didn't ask what the huge shift was? Wait, what do you mean you became angry all of a sudden? Can you, like, she became angry. Because all of a sudden she started remembering how he used to choke her. She got angry. And then she shook the suitcase, and then He was trying to put 2 fingers out of the suitcase, and so she hit it with a bat. Period. End of story. That's it. That's all you would have on that? You wouldn't say, okay, we're going to start then from the beginning here. Is this something that you guys normally do on Sundays? Is this like a normal thing? Like Sundays is a day that he would never work, and, you know, is this part of your routine? But that's all she said. But she was able to read that down like that without any notes. Then she had to get her notes to then recall. And I was like, wait a second. And it was, you know, it was, let me refer to my notes after she's coming down the stairs and seeing him in the suitcase. And I'm like, this is the most important part. What do you mean? How do you read off your notes, or you didn't need your notes for any of that other stuff, but then you need your notes for the most important part, which is, and then this is what she had to refer to her notes for. The laughing and enjoying, and then all of a sudden she became angry. And I would want to know, so I made a note to myself is, did you not write down what was the sudden shift of where the anger came from? Where did your anger come from? What triggered your anger? Was it the alcohol, do you think? You know what I mean? And guys, I'm sorry, but I don't give a fuck if Sarah Boone had a job or not. If Sarah Boone had money that she was living off of because of a settlement, we should probably know more about that settlement. You know how many stay-at-home moms live off of fucking divorces? Come on, man. So she's got it like that. I guess she can afford to do that. You know, I think it's wild that she only got $100 a month for child support. How the fuck is that possible? That's $25 a week. You guys have any idea how much I spent on my child? Like, what? How could she only be getting $100 a week? But there's no substance here. There's no, like, I could never think in 1,000,000 years that me as a person, professional, friend, doesn't matter, that I would think that I could get up on a stand when someone's facing murder and say, hey, I talked to this person for 2.5 hours and I'm able to give legal opinion. 2.5 hours. Again, professional, not friend, not, I mean, I was around that person for 2.5 hours and I can get up on a stand and think that I can diagnose anybody. I'm sorry, but I think that's wild as fuck. But if that's so true, guys, if that's so true, then I think we should stop going to therapists. No, that's just a money grab if I ever saw one too. Dude, they tell you what you need to hear, right? Because they need you to keep coming back so that they keep making money. Because if they truly told you what they thought, you wouldn't go back to them. I mean, fuck. I talked to my therapist and it's all about feelings. And when you say, this is how I feel, you're never wrong. So is that how that made you feel? Yes. So you want to talk about your feelings, and that's how you can always have the upper hand in conversations with somebody, just so you guys know, okay? This is my feelings. And my feelings aren't wrong. It's how I feel. So are you going to acknowledge my feelings here? Sure. That's how you feel. Awesome. This is how I feel. This is a fucking waste of goddamn time. That's just what I think. Or we can truly talk about the root of the issues. Okay. But I feel that you do not have sex with me enough. Okay, well, I guess proffer me. Proffer me. Yuri's math teacher coming in with 5 large ones. I would like to proffer that I am going to be a Lil Wayne cop tonight. You guys like that? I've never met a therapist I felt comfortable with. Yeah. I'd rather talk to my friends and then say, hey, what do you think about this? You think this is normal? Well, what's normal nowadays? Well, I mean, I don't know. Do you think this is normal? Would you ever do this? How would you feel if someone did this? You know, I'm going to go see my therapist. All right, you go and do that. And I'm going to tell you what they say to me. All right, you do that. I personally think that it should be couples therapy or no therapy. You're both going to get your happy asses in there. Okay. Because why would you ever go to a therapist and lie to them? Like, that's got to be wild as fuck. I went to my therapist. What'd you tell him? Well, that's a damn lie. You know? Oh, shit. You know people do it, though. All right. Looks like we're back. We're back in biz. Let's see what happens.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone.
Owens!
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony?
I know it's
Okay, you may
crazy to me. Isn't it nuts? I think it's wild.
Hi, Mr. J. Question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant related them
It's
to you,
before this.
what would be your answer? Question. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question. If you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question. All right, that's it.
I don't think that's the very beginning.
Exactly, it's not. Exactly, it's before it.
What was asked was to read back the proffer.
No, it wasn't.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because
No,
the
it
question
wasn't.
before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition.
Yeah, and you have to go back to the testifying part.
The question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. That the answer was supposed to be something different.
We wanted to hear the answer in the
as
question.
identified in the proffer.
What the fuck?
Which is why I had Madam Court Reporter read back the proffer.
No,
So the
why?
question
Who cares about the proffer?
Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She
said
tended
no.
to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay, my question is specific as to opinions. Her
He said
opinions
no.
were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, the answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering unless I misunderstood the proffer, she's
You
not
were
rendering an opinion on PTSD and whether or not.
This isn't
Ms.
about
Boone
the
suffers
goddamn
from it.
proffer.
She led me to believe that she was trying to decide whether or not.
What the
Sarah
fuck
Boone
aren't you
suffered from
getting?
post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on, when a question was asked, and I believe she rendered an opinion.
And then you objected.
Again, like that, we read back what the initial question was, what the response was, because it did. I know I objected. I can't even remember it now, but I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection.
He's the.
No,
The defense
Madam,
attorney's
if you
right.
want Madam Court Reporter to go back and read
Yes.
the question
Yes.
that led us to where we are right now and the answer, I'm totally on board with that. I have
Yes.
a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So I can-
Let's just reread the entire proffer, just so that it's
fucking
a clear soup to nuts, alpha to the omega,
Brian's
what
case is going great.
the proffer was. Madam
Huge
Court Reporter, if you could be so kind.
fucking A.
Yes, ma'am.
Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
I can't believe that she's able to sit through all of this. Right now, I'm voting not guilty. This. Yeah, I'm not God either. But everybody's innocent until proven guilty, so that's why it's innocent for me until proven guilty. I see two completely toxic human beings in a toxic environment, and something bad was gonna happen. I mean, I already feel like bad things were happening. They were getting arrested, for heaven's sakes. Okay? Like, it just sucks that they didn't have family. I would love to hear more from the ex-husband to why were you allowing to even like drop him off there? Like, people are calling people unfit parents because they, I don't know, have a beer on a fucking live.
Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me.
Okay. All right, here we go.
Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Thank you.
Can you read that for me one more time, please?
Yes.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Maybe we please have the previous question as well.
Oh, shit. See?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end some general, if you have any new opinions or anything new that differs from what you said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got
It is
a right to be prepared
Brady
for the trial through discovery to know what the witnesses.
It's not Brady. It's a discovery violation.
And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I asked that the witness be stricken.
Yes, he said stricken.
Judge, I think it's clear from my original question that the intent that I stated.
It doesn't matter what your intent
is.
is.
The answer that I intended to get was what the question was intended.
It doesn't matter.
To elicit from the witness.
It does not matter.
As far as the discovery violations and continued attacks, I'm just not. I'm not convinced he understands what the answer means or what it's going to be.
What?
The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case.
Mm-hmm.
What I believe she's going to say, and what I believe I've been saying she's going to say,
Void
based on
dear
our
her.
conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of this.
That should have been a given.
That, not the state.
Any other argument?
The totality, if you read
Yes.
that deposition and all that we talked
I
about-
specifically asked you, Mr. Owens, to point out for me
What?
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us.
Oh.
If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them,
Well, the ones that I expressed.
other than what you've already identified.
You didn't say
the ones that I
60.
expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J? Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
No, other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense.
Woo!
As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far are do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it?
Ooh.
Mr. Owens. Because my question is, do you want it struck?
We want her whole testimony struck.
On that issue, we'll address it on cross-examination.
So you do not want it to be struck,
Strike that
and
shit.
you do not want a curative instruction.
Stop.
Well,
No!
I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the
no,
questions and
no.
answers and the readbacks of both the proffered testimony and the opinion testimony?
The jury's not
And are
going to
you
get
on board
that.
with the strategy not to seek to strike that opinion?
Yes.
Thank you.
I would never do that.
With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions.
Oh, okay.
And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited.
Come
But with
on, what are you
regard to
thinking?
the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time.
What the fuck is wrong with you?
You may proceed.
Dr. Warren,
Yes, sir.
good morning.
Mark?
He better bring it.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay.
That's not what you just said.
And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
You made that.
When did you form that
when-
opinion?
Yeah, when?
when she described the incident to me.
Did you make
Why
that
didn't you
known?
let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that.
Yes,
but
he
you're saying
did!
you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition. Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be
She
expressing
did ask.
in the
Yes, there it is.
Sarah Boone case.
I didn't know what specific information you wanted.
It doesn't
sir.
matter.
That's why
You just
had
give
a
your
deposition.
opinion. What
I
is it?
answered your questions. I don't
It doesn't
know
matter.
what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked.
Oh, wow. She's fucked.
I don't know
That's-
what questions you want me to
But,
answer.
but you know that this was a central issue in the case. Did you not? Your opinion
Yes,
is relating to a central issue in this case.
correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
Well, okay,
That's all
perfect.
what you've got.
Now she's fucked. I have a number of opinions.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship
Ask
with
for a
battered
fucking
spouse syndrome
recess.
and or post-traumatic stress disorder as proffered.
The
Ask for a
problem is
recess.
now, Judge, is I've got my expert, and we weren't aware, you know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts.
Yes.
Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
And that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just
This-
puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom
Yes, sir.
and we're
Under
waiting
oath.
on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who is on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial?
I disagree that there's any hiding of the ball.
There's
There's been a proffer.
this
It's
witness
been
is
read
hiding the
multiple
ball.
times. as to the scope of the opinions
Fuck her
regarding to
scope
battered
and your
spouse
scope.
syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant
You're gonna
represented them.
get totally
And the
fucked
answer
on
is they
appeal,
are
buddy.
not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Dr. Werner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she
Just
needed
like
to
I
share
asked
with me
you.
at the end of my evaluation, and she
Just
said
like
no.
I just
So a
asked you.
catch-all question.
A catch-all question. Just like I asked you. Say it.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
Keep going.
So
Get her.
narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I'm leaning towards the adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
When did she review?
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
In your opinion, does she suffer from any form of psychosis?
No.
How long did it take you to look at
Is
your
it your
notes?
opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of a the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
That's not what she said earlier. I mean, am I losing my mind here? I swear she just flipped her fucking switch right there. Okay, Owens is reeling it in.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just
I would-
Okay, all right.
Yeah,
The court
a
has
standing
conducted its
objection.
Richardson hearing and made its findings. The court, as previously identified, will not strike the expert as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
Yes, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us. They've been here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
and we're not in our defense, our direct defense. Is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek sir rebuttal and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
It doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning.
Ow.
I'm going to ask you to be excused from our proceedings.
Get
Not
out.
view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give. And then comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
I don't believe he waived. I mean, on appeal nowadays, you can. There's a lot of things you can do. She can use it as ineffective assistance of counsel. There's always loopholes. She can use ineffective assistance of counsel right there. This is wild. Do you guys understand that, like, in the see how loud that is? Like, that extra noise? I need to switch. Like, what is this long crime? I'm switching. Like, this is horrible. Like, fucking A. It's like all that white noise. Like, what are they doing? I'm switching providers. Switching damn providers. Where's okay, thank God. It's way better. Balls.
Bless you.
Ridiculous. Yeah, is that better? Thank God. Ugh. This is wild. There.
State
Thank
to
God.
recognize our jury.
Yes, Your Honor.
That's to recognize our jury. I thank y'all. You can be seated.
Oh God, that's so much better.
Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
The judge is probably like, I don't even know what that was. All right, guys, welcome to the transparency. I mean, I'm just telling you, if I'm on the jury, I see a woman that has spent 9 times with Sarah Boone. 9 times. Okay. And then I see a woman that just comes into the mix of things right here at the end, the tail end. And it's going to come up here on cross that she changed all of this shit. So, I mean, we can say right now we're judging him. And you guys, cross-examination is a very, very powerful tool if you are good. And how you are good at cross-examination is, first of all, you have to know your case. You have to have the material in order to cross-examine somebody. Your cross-examination is going to blow dick if you don't know your shit. If you pay attention to detail like myself, that's where I think my strength is be able to help a
Your
defense
objections
team
overruled.
or prosecutor cross.
Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Yes.
What, this woman didn't say any of this shit. I mean, what is she doing? That's her opinion of the situation, just like it'd be my opinion of the situation. That's what? I'm sorry, but that's just not that's not an expert opinion to me. It would be also ineffective assistance of counsel that that Owens didn't ask her to leave. So, I mean, this is why you have like assistant coaches, you know? Jose Baez is as good as he is because you know how good his right and left hand are? The fucking pimp hand is so strong with Jose Baez. You're only as good as your team, man. That's why Truth and Transparency rocks. Because the people around this channel are good. I just get up on a mic and rant. I think Owens is done. Yeah. I mean, he had a decision to make. So we'll see how it goes here on cross. But for me as a juror, I'm looking at somebody that spent 9 days on 9 separate occasions with Sarah Boone. And here's somebody that spent 2.5 hours. Okay. And her opinions of something after 2.5 hours, I don't give a fuck. I have a problem with that. You know, think about if you take your kid somewhere. People like, oh, go get your kid checked out for whatever. You know, nowadays it's just big farm. Like, oh, your kid's got this, that, and the other. Like, they can't focus. They got ADD. Go get them checked out. You know, they got behavioral issues or whatever it may be. It's just like, dude, what? You just want to like diagnose fucking people. No, but would you ever take your kid to somebody and after 2.5 hours, let them say like, this is what, like, yep. And if you would, hey, that's what you would do. But I'm telling you, I would never. Like, I really like to hear what teachers have to say about kids. The teachers are with these kids for how many hours a day? Okay. Teachers know more about our kids than probably we know about our kids. Think about it. Think about it. They're with them more hours out a week than we are. So like listening to a teacher at parent-teacher conferences is something that you should value because they're with your kid all this time. They're not making their opinion off of, 2.5 hours. And I look at teachers as experts in their field. I do. Especially if a teacher, how many teachers have master's degrees? A lot of teachers have master's degrees. I think that teachers are going to get paid more. Shit, nowadays, like, we never had to worry about kids coming up into a school and shooting it up. Like,
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
Paula says, I always point out that Lana knows her shit and don't go there. Oh my fucking God, I'm out because of all the sidebars.
Y'all can be seated. Thank you.
Oh, Paula, thanks.
Madam Court Reporter, when you're ready.
Oh my God, what the hell is going on now again? Oh, love your channel. Oh, thank you. Just stick around. We're having fun. Who cares what the hell they're doing? I'm just shaking the cowbell. Yeah. Teachers should get paid more. OJP. outside it's supposed to, outside the presence of the jury, but they want to say outside jury's presence. That's fine, but Hannah, don't fuck with me, man. This is just wild. There are some shitty ones out there who could probably, yeah. Just like anything in life, there's shitty people everywhere, and in any, that should tell you that people can, put a nice little facade on, but in any capacity, in any field. Things are really heating up in the Delphi case. That white noise, I mean, was it like that for the Karen Reed case? This is the channel to watch Boone trial. Only one who is listening to Sarah's side. It's refreshing. Thank you so much. You're hired if I ever commit a felony. Yeah, definitely bring it on. Especially even if you don't commit a felony and you think that you didn't commit a felony, but you didn't realize that what you did was a felony. There's a lot of things around that. Absolutely. Anybody dressing up for Halloween? I am. Do you guys know that every year did I do it last year? Oh wait, is she ready to read it back? Oh wait, sorry, hold on.
Perspective of whether anybody has any opinion about whether this building is suffering from PTSD.
Okay, here she goes.
Yes, ma'am.
Thank you so much, Paula.
Just read it from the question, answer, question, objection. Let's just have the.
I can only help people if you have a discovery. If you have a discovery, I can fucking get you off anything.
Go ahead.
No.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether this building is suffering from PTSD or ESS, irrespective of that, based on your evaluation of this building, what she relayed to you about the facts of this case, does PTSD or BSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury.
Told you. That's a lay answer.
Science or medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify. That you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
100. That's ridiculous that she said that.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony. And it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said,
No.
BSS does apply, and that she's in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
No, it's
Any
not.
other argument, Mr. Owens?
Yeah.
Totally wrong.
That's
He claims, the prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and the answer, and then I have no further questions of the witness.
Okay, thank you.
I'm sorry.
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There is a pending objection. Allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for mine.
We're going to begin your cross-examination after we're done with the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel.
I want that book that he has. Where'd you get that book at? I want a book like that. I'm gonna go to the library. Go to the law library. You guys ever go to the law library? Mosey on over to the law library. That's where I pick up all my dates. The law library. I'm like, you can write me up a motion. I'll buy you beer. You guys, I don't even. This is wild. Black's Law Dictionary. This cross is going to be lit. It's going to be very fiery. Who's Owens's hot piece behind him? Woo! Give it up for those women in the suits.
State to recognize our jury.
Without the
To recognize
pants.
our jury. All right,
The
you may be
skirt
seated. Thank you.
pants.
Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Pesky became a new member. Chantel became a new member. And Yuri passing out some green stickers. 5 of them.
Question by Mr. J. All right, irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and DSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek, they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
All right, cross-examination. Here we go.
Good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copsey.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection to the approach.
Yes.
She doesn't know what's relevant and what's not relevant. Okay, guys, this is wild to me. She just said on the stand that she did not have time. She did not have time. You guys, what? That's all. He doesn't need to be combative with her. This is one thing I've learned. Okay. Sometimes less is more. Okay. So it's important to, like, I guess the question could be like, oh, do you have a lot of caseloads right now? Did the state ask you if you could, properly prepare for this case, that it was going to be a lot of time, but okay. So didn't have time. So she did not say that she saw the video. So what did you consider? They considered the Orange County, basically the criminal investigative report. Okay. And then the transcripts of the interview with Sarah Boone, they're labeling this number 1. And there was a second transcript interview of Sarah Boone.
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Another question, sir.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Unbelievable.
read all the text messages, and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
You guys, I told you. October 2nd, 2024, 22 days ago. So you reviewed all of this information that you just said before you then evaluated her for the 2 to 2.5 hours. Okay. Why would the state, listen to this, guys, why would the state hire her so late in the ball game? Because Sarah Boone did what, ladies and gentlemen? Sarah Boone got herself some representation, some solid representation. They offered Sarah Boone a plea deal. Sarah Boone turned it down. Then what do? Fuck, we got to go hire somebody to combat this Dr. Harper shit. Last minute, 22 days ago. Okay. Sarah Boone has been incarcerated for 5 fucking years. Sarah Boone has been incarcerated for 5 fucking years. Did you watch the trial? No. Did you see anything that Sarah Boone testified to here today? No. Didn't have time. All right. If that ain't cringe over there on Law and Crime and Court TV with the voluntary bedbound bitches, okay? Voluntary, keyword there. And the keyboard warriors over there, then I don't know what is. You do realize that Sarah Boone is on trial for murder, right? We ain't got no time for that. I've been like, I don't have time. Like, what do you... Okay, I have to look at all this stuff. Like, oh my God. And then I have to render an opinion. Oh my God. And then I have to testify. Oh my God. 22 days. Murder case. And I got to meet with her. How much did she get paid? How much were you paid by the state? What's your billables at, baby girl? Talk to me. What do you at? About 500? 500? Okay. All right. Unreal. I'm really disappointed in YouTube creators that are mocking her views. Absolutely. Absolutely. 100%. You know, the thing that's really crazy about it is that nobody knew about this, okay, for 5 years. But I think that mainstream media did, okay? Because guess what? I never covered this case, all right? And what you would have been able to get is that the cops were out at Sarah Boone's house a lot, all right? You would have been able to get some information. Now, when things are like domestic violence, like they do protect you, all right? But nobody, I mean, Sarah Boone and this man, like, and people like look at that and they're like, oh my God, she's laughing or she's smiling. That's why I was so happy when Rosie said to the jurors during jury selection, hey, if you ever looked over and you saw me conversing with whoever, it could be my, associates, it could be Richard Allen. If you ever see us like smile or laugh or whatever, sometimes you have to put us, we're humans and we're talking about stuff that's not even about this case, just to get our brains away for a little bit. Okay. Because it is, it's very serious. That doesn't mean that we don't take it seriously. But he's like, would you guys ever use that against us? Would you guys ever hold anything like that against us? Okay. Because we wouldn't hold that against you, but he wanted to know, are you able? So he already put it in their minds, like, please, like, I don't want you guys second guessing what we're doing. I'm just going to tell you what we're going to be doing over there. There's going to be times that we're very serious, writing down notes. There's going to be times that it's a break or whatever, or someone's doing something that has nothing to do with this case and it made us laugh, or, don't hold that against us. Can you do that? And same thing if the prosecution was to do it. Okay. That does not mean that we're taking this lightly or that we're taking this as a joke. It is human behavior to want to talk about something that has nothing to do with this very serious and gruesome situation that we're dealing with. Okay. And we're humans and we're conditioned to help soothe ourselves. It was very awesome. Okay. It was so awesome to see that being addressed during jury selection. That's why I stand by that. I believe that Richard Allen's jury is anything that Karen Reed had. Okay. Anything that Karen Reed had. And it was so efficient, and how quickly it went isn't because they were just picking whoever. They had a 50-page questionnaire, which is very extensive. And out of the 600 people, they put them in order based on, in my opinion, how I saw it, is they did it based on the jury questionnaires. Like, who are your best people? Like, who do you think are your best people? And then when they were put in these groups of 12 to go into the box, it was 6 prosecution and 6 defense. That's what I saw. That's my opinion. I don't have anything that says this is exactly how it went, but as a logical, reasonable, common sense human being, that's what I saw. And that's why it went so quickly. So I struggle to understand, how many people that I've not been fans of that have been defendants, and it's still like, hey, I'm not a fan of Scott Peterson and that he was a cheater, and but I'm also not a fan of cheating, like cops cheating, like people not doing their jobs. I'm not fans of lawyers not doing their jobs. I just Is the state complaining? They think that he's badgering the witness? Badgering the witness. All he's got to show is that his expert spent 9 days with her. 9 days. 9 days with her. Well, both sides. Yesterday, you guys, she tested like I don't even want to say that tested positive. She tested positive for narcissistic traits. No, in these administered tests or their evaluation process, both of these people have said that she has narcissistic traits. A lot of people have narcissistic traits, but it doesn't make them a narcissistic person. Okay, and so she's already said that she has narcissistic traits. That woman has already said that on the stand. Meaning like the woman from yesterday. So like I would want it that those two having like the same opinion with that, you know. And then the reason that you weren't able to get anything more out of her is because you didn't spend any time with her. You didn't spend any time on this case. You know? So I don't know. I think the two people that we never thought were going to be MVPs of this trial became like really important people in this trial.
Objections overruled. You may proceed.
Thank you, Judge.
All right, here we go. For the record, if they were zoomed in,
Fair to say,
if they were zoomed in on Brian Colbert right now, shit would be fucking hitting the fan.
2024, that you felt like the text messages that you received from the state attorney
Overruled.
are not relevant to your evaluation of Sarah Boone.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes.
And we discussed that these were the phone records from Sarah Boone's phone.
Yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
You got it.
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any.
Let him finish.
Boom. This is really important.
I'm going to ask another question about the text messages, Judge.
You just said line 5. Approach.
What the you guys, this is why this is important. Remember in the text messages, I'm gonna handle him. I'm gonna handle him. I am gonna handle him, right? She's said in her deposition that she did not find the text messages relevant. Okay? This is what was said in the text messages. This is why this is important. She doesn't believe this is relevant, which is really important. Take that, Court TV watchers.
Did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14, my question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I can
talk.
read my
First, you
complete
said
answer.
no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
No,
It's not my
comma.
complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile
What is she
relationship.
doing?
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship,
Correct?
and this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object. We need to approach.
What? The answer to that question is yes. You guys, she didn't even find the text message in quotes, I'll handle him. This is what everyone's going nuts about. This is what everyone's calling premeditated. You understand that? You understand that? The state got this witness 22 days ago to try to get up here on a stand, try to cram all this shit in, to evaluate her, look at her, the material, and to form an opinion. I mean, this is Sarah Boone has been incarcerated for 5 years. 5 years. And the state just now, 22 days ago, hires her, gives her the criminal report, transcripts of her first interview, Sarah Boone, a transcript of a second interview, medical records from 2 different hospitals, cell phone records, and then the deposition of Julie Harper, their expert, the defense's expert, and text messages. Did you watch the trial? No. You know that you could have, right? Yeah, I didn't have time. So you received all of the info before evaluating Miss Boone for 2.5 hours, all that stuff, right? Yeah. And now her deposition was done via Zoom. So the lawyers were all Zoomed. She Zoomed, which is wow. Wow. I mean, they can do stuff like that. You can do Zoom depots if you agree. Everybody has to agree. I would never recommend that, but whatever. Murder case. How does this, for somebody to, there's expert deadlines. How did this happen? There are expert witness deadlines. She's a rebuttal witness, isn't she? She is. That's how they got her in. Holy shit, they missed the expert deadline and then they had to get her in as a rebuttal. Holy shit. That's why she's a rebuttal. Because you guys, in your case management, you have deadlines, all right? And then after that deadline, you fucked, all right? Well, what I just realized, the lights just went off in my head, and they got this witness as a rebuttal witness, which your rebuttal deadline is always way later than your expert deadline. And how do I know this? Well, because of the Drake Moore case. Because I fancied something up extra special in that case and proposed something along these lines. But so I wonder how the jury feels. More cowbell, please. 22 days ago, hired $500 an hour. You guys know that she's getting paid for this, right? $500 an hour plus your travel. Okay. She already got paid to do the evaluation, then the deposition. So, I mean, how much money do you think she's racked up right now? At least 15 grand. Do you guys understand that 2 hours is just
All right. Members of the jury,
$1,000?
it is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up.
Oh, thank you so much there, Paula.
Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service. Y'all may be seated. State, anything else?
No, Your Honor, thank you.
Defense?
No, sir.
All right, we'll see you at 1:30. Thank you very much. Court's in recess.
What the fuck just happened there? That's really weird. Did they dismiss the witness? When did she get down? Usually they let her go. They let her go first. Bye, everyone. It has been an eye-opening experience. I'm glad, Lana, you're covering this case. Said Sarah deserves support. I just think it's crazy. Okay, so we are on lunch. I know that, but whatever. All right, let's go talk about some Delphi stuff. So this is back on at 1:30. I have a live set because I wanted to do jury deliberating, but I didn't realize it was going to be like, I thought it was going to be quick. So I'm going to have to change that live because I'm going to do the live call-in show during the jury deliberation time. So I'm going to be doing live call-in shows during the deliberation time. But Sarah's been incarcerated for 5 years. Nobody knew about any of this domestic violence. And if they did, shame on them. All right, peace out. Thumbs it up. Let people know. Be back here. People are saying that Sarah's going to walk. I hate when people say that. I just don't think the state has proven their case. Okay? All right. Yeah, closing's not till tomorrow on this case. Yeah. So, what does Delphi mean? Well, I guess come back and find out. Peace out. Look at what's Court TV doing? Oh, there we go. Thank you guys. This got juicy.